This TV show is made available to provide general information and a general overview of legal principles. Viewers should not rely on the information provided without consulting an attorney who is licensed to provide legal advice. Topics and ideas shared on this show are not to be used as a substitute for legal advice from a licensed attorney in your state.
Hi, and welcome to Under Oath with Michelle Bell. I'm your host, Michelle Bell. Now, this is a show where I bring on fellow attorneys and we give you, the public, legal information without the consultation fee. So I like to start the show off with a segment I called Jury Duty. And this is where I give you a trivia question. And the first person to send in the correct answer will have their name posted on the website. Now, the website is www.mbunderoath.com. Ready for the question? Okay, here we go. What is the most common type of pitch thrown by pitchers in baseball? So send in those questions. Also, while you're there on the website, subscribe. Subscribe to all our social media places. We're on Facebook, Twitter, YouTube, Instagram, Periscope. Just find us and subscribe. You will get notifications of the new shows, you can watch the old shows, and you can get the legal tips that we send out weekly. Now don't forget, send in your answers for the show and come right back after the commercial. I have a special guest for you.
So there you are, shuffling through a stack of resumes and you come to mine. This is it, first impression, my way in. But can my resume show you how I truly stand out? Like that I was studying, going to night school while working 2 jobs just to help my parents pay for groceries. Or being the first one to always step up. No, that's something you just can't put on paper. Look beyond the resume and discover new ways to develop great talent that is dedicated, hardworking, and determined like me.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. I'm here with our special guest, Mr. Glenn Garnes, who is actually my mentor, so that's great, and a retired attorney. So welcome.
Thank you for having me.
Thanks
It's a nice
for
place
coming.
you got here.
Thank you. Well, tell the audience a little bit about yourself, because you are a retired attorney, but you're still going to be here talking about, legal issues.
Sure. So I love the retired title because I've been retired for almost 20 years now. But during the period of time that I was a practicing attorney, I started off in the area that people would consider to be personal injury, and then we're going to talk later about workers' compensation. And I also then migrated into business, and that's what I ended up doing before I closed my law practice, was representing business owners.
Okay, so in the field of law, what do you still do now that you're not practicing, you're retired? What do you still do? Nothing?
Nothing.
No teaching?
Well, let me say this. I do teach. I do work and help other lawyers with their practices on a more of a mentorship basis. And I still maintain my licenses for people that have a need for pro bono assistance. If they can't afford an attorney, then I take cases where someone needs help and they're not in a position to pay for an attorney.
That is very nice of you.
Well, it's I don't know how nice it is. I just enjoy it. Sometimes I do like to get into court knowing that this is no longer the way I make a living, but it's just what I do for entertainment. So
Hey, it works. You can still use your law degree. You took time to get it
went
and
through a lot
pay
of
for
trouble
it.
to get it. You're right.
So might as well use it. So, okay, good. So the topic we're going to cover today is what? Workers' compensation?
That's it.
Okay, so everyone calls it workman's comp. It's not. It's workers' compensation. So, all right, so where are we going to start with workers' compensation?
Why don't we start talking about what it is?
Yeah, sure.
So, and this is important because a lot of people get this all balled up. Workers' compensation is merely a system that covers people injured on the job when they, when their injuries are something that happen as a result of what they do for work. So what I mean by that is that, if you're driving a delivery truck and you have an auto accident, that's done in the course of your employment. So you're able to make a claim directly against, or directly not against, but with your employer for your injuries if you're injured. If you fall off of a ladder while you're working on a construction site, if you slip and fall in the bakery while you're making baked goods or whatever, those are all situations that are covered by workers' compensation. So it's designed to pay people compensation during the time they're recovering from a work-related injury.
Okay. So people get an idea, okay, your injury happens while you're doing what you're supposed to be doing at work, not off doing a detour like you're supposed to be delivering and you went and stopped at the cleaners and ran some errands because they were in the same area as where you were supposed to be delivering. There's a difference, right?
Well, you're absolutely right. In most states, now now this gets a little confusing because in some states that might be compensable. And this is why you need an attorney, because there are certain situations where there's a bright line rule, and then there are others where there's a gray area, and you might be entitled to benefits even if you weren't doing exactly what you were supposed to be doing at the time. But as a general rule, workers' compensation covers injuries you incur on the job arising out of and in the course of your employment. Arising out of means caused by what you do. Fell off the ladder because you were painting. In the course of means during the period of time you were supposed to be doing it, work hours, et cetera, or during the time the employer expected you to be working on his or her behalf. So it arises out of and in the course of your employment. If you can prove those two things, then you're entitled to workers' compensation benefits.
Okay. Now, when you did workers' compensation, did you do it from the employee's perspective or the employer's perspective?
Both. I started off early in my career representing claimants and plaintiffs in either personal injury and workers' compensation cases. And I did that for the vast majority of my career. Towards the end of my career, when I started representing the business side of the interest, I did get hired by self-insured employers and by insurance companies to represent their interest, the interests of the employer in that process.
All right. So purposes of this show, let's go from the employee's perspective, which is the claimant.
Sure.
All right. So I'm an employee. I'm working in a bakery. I'm making donuts, and I slip and fell off some flour or something that ended up on the floor, and I got hurt at work during the time I'm supposed to be there doing what I'm supposed to be doing.
But you got that all down, right?
Yeah, So what do I do? What's the first thing I do after I get some medical attention?
So it's important for you, actually, to the extent that you're able to do this, it's important for you to give your employer notice that you were injured so that you can identify witnesses and make sure that people are aware of what happened. The closer in time to when the thing happens that you alert people, the more likely it is that the claim won't be contested as something that someone fabricated.
Okay.
So you want to notify your employer. If you need medical attention, you should get it right away. And I know this sounds a little self-serving, but the point is, as an attorney, I believe that you really do need to have someone represent you, even if it's a very simple claim. Let me give an example of why. In some states, in Maryland, for example, arising out of in the course of employment has one additional caveat to it. It has to be accidental. So the question becomes, let's say, for example, you were carrying a sack of flour and you strained your back. It has to be, the definition of accidental means it has to be an unusual result. Well, we strain our backs all the time carrying heavy things, so that becomes an issue of, was that unusual? But if you were carrying the sack of flour and the weight shifted and caused you to almost drop it and you went to catch it, and as a result of that you injured your back, that's more likely to be compensable under Maryland law. So every state has a different standard when it comes to what constitutes arising out of and in the course of employment, whether it's an accidental injury and all that kind of stuff. So you want to make sure that you contact an attorney before you commit yourself to a story that has to be reported to the insurance company. Every employer, this is like an insurance claim. So every employer has an insurance company that covers you for workers' compensation. So after you give your employer notice, verbal notice, they will give you claim forms and a notice. And frankly, you should take that and get your attorney to help you decide what to put down there. Sometimes it's not what you say, it's how you say it. I slipped while I was, the flour slipped out of my hand, and as I was trying to catch it from falling, I strained my back, as opposed to I was lifting a really heavy sack of flour and my back started hurting. In some places, in some jurisdictions, that's not going to constitute an accidental injury within the meaning of their workers' compensation laws.
Okay, so that little nuance could be the difference between you actually getting enough money to assist you to get back to health, or you just out of luck.
That's right. That's exactly right. What you say about now. Now, in some jurisdictions, as I said, it doesn't matter.
Right.
We're here in the Washington D.C. area. D.C. is very, very liberal on that, and it's very easy for you to qualify as long as you injured your back while you were doing what you were supposed to be doing at work. It's going to be compensable. You come across the border in Maryland, it might be a different result. It might be a completely different result if you go across the border the other way in northern or in Virginia. So it matters where you are. You know, every state is not the same, and it also matters in terms of how you describe how the incident happened. So you can notify your employer, because they're not going to typically know that you need to describe it this exact way. But once you put it in writing, it's hard to backtrack from that, which is why you should consult with an attorney before you do put it in writing.
Okay. So now I fell, had this problem, got up. One of my coworkers said, you need to get a lawyer. I went and get one. We've notified the employer that I fell, I was injured. We filled out the paperwork. So now they're on notice. What happens next?
Well, if you are injured and unable to work as a result of the injury, there is usually a statutory period that you have to be unable to work before benefits kick in. That can be 2 days, 3 days, it might be longer depending on the state that you're in.
Okay.
But assuming that you're off work for the statutory time, your employer, your doctor will give you a disability certificate to say, you know, I want them off for 2 weeks or whatever. And you will start to receive benefits assuming the claim is not contested by the employer. Okay. And then you just follow the doctor's advice. Your insurance claim will you'll start to receive benefits once you have filed appropriate paperwork. And then once you're better, you just go back to work. Your medical bills are covered. Your lost wages are covered. And let me explain something about lost wages. This is important for people to understand. You're not going to get the same pay that you do when you get your paycheck.
Right.
It's going to be less. So just expect that, because there are reasons for that, and we'll probably end up talking about that a little bit later. But don't expect to receive your dollar for dollar compensation, and you know it's not designed to completely replace your compensation, your paycheck, because they want you to go back to work.
Right.
You know, if you can make just as much sitting at home with your doctor as you can at work, you have less incentive to go back. So they're not trying to make you completely comfortable at home.
Right.
So.
Okay, well, good. Right now we're going to take a break, and when we come back, we're going to go into office hours, where I'll ask you questions that were sent in by the audience, and then you can answer them the best of your ability.
Sounds good.
Okay.
All right.
All right, when we come back, we'll do office hours. We'll see you then.
What do you think you're doing, Kevin?
Was just gonna drive home.
There are several warning signs present that you shouldn't be driving.
Like hearing voices.
Like your text-to-emoji ratio.
Oh man, the selfies. Selfie, nailed it.
We all have warning signs that let us know that we're probably not okay to drive. Mine is pretending to be your subconscious.
Craig, come on man, let's put a ride home.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. We're still here with my guest, Mr. Glenn Garnes, and we were talking about workers' comp. So we're going to go into office hours, where there were questions that were sent in by you, the audience, and Mr. Garnes is going to answer those questions the best that he can. Are you ready?
I'm ready.
All right. So they are not audio, which we're probably used to. They were emailed in, so I'm just going to read them to you, okay?
Fine.
All right. First one. How do I get paid for pain and suffering?
Okay, you don't is basically the answer to that. Remember, workers' compensation is designed to compensate you for the loss of wages that you experience as a result of an on-the-job injury. And the reason that's important is because pain and suffering is a concept that's associated with a fault-based system. Someone rear-ends your car while you're stopped at a street light or whatever, and you prove that they actually were negligent or they were at fault for the injury. They have an obligation under law to compensate you not just for your out-of-pocket expenses, lost wages, et cetera, but also for the pain, suffering, and inconvenience it results from your having to have to deal with the injury in the first place. Workers' compensation is a compensation system that protects injured workers during the time they're unable to work because they got hurt on the job. So there is no pain and suffering. What you're entitled to for workers' comp is lost wages, time that you're out. You get your medical bills paid. And if your injury is permanent, then some compensation is paid for your permanency of injury. And that's based on how much use of your body you've lost as a result of the injury. If you broke a finger, or if you lost a finger, something like that, there is usually a statutory measure of how much that affects your ability to earn wages, and you can be compensated for that permanent loss. But it's not pain and suffering. It's simply a function of how much capacity to earn wages has this person lost as a result of the injury, and that's what they're compensating you for. So no pain and suffering.
No pain.
Don't ask your attorney about pain and suffering.
Right.
You're not going to get it.
You're not going to get that extra. Okay. Well, that's great. The second question, do I have to pay taxes on my workers' compensation benefits?
No, you don't. And that's why you don't get your full paycheck. Because when you get your workers' compensation benefits, they already take into consideration that you're getting less than what you're actually making when you're working full time. So you normally get somewhere in the neighborhood of about 2/3 of your normal income, because A, they want to pay you just enough that you have incentive to go back to work, plus you're not paying taxes on it either. So in the scheme of things, it's actually pretty fair.
It works out.
Even though, but again, you know, they want you to go back to work. They don't want you sitting at home trying to make a living off of workers' comp.
Right. I think that's all the questions we have, but you did make a great point when you answered the first question. So you said that there are statutorily amounts that you would get if you had permanent damage or stuff like that. So when you say there's a statutory amount, what do you mean by that for the audience members that don't understand
Okay,
the
let me see if
statutory
I can
language?
expand on that a little bit. Every jurisdiction has a workers' compensation statute that governs what's available to the worker in that state. And there's usually what's known as a permanent loss schedule. That schedule dictates what the worker is entitled to when they've injured a hand, a foot, a finger, their back, or some other part of their body that affects their ability to earn wages. So if the injury doesn't really affect your ability to earn wages, like if you have a scar on your chest and you don't, like, you're not a lifeguard and nobody cares because you wear clothes all the time, that might not be something that affects your ability to earn wages, so it doesn't become an issue. But if you break your finger or you break your hand and you can't make a grip, you can't grip as well as you used to, that might be something that would affect your ability to earn wages. If you injure your back and now you can't do heavy lifting anymore for the rest of your life, that would be something that would affect your ability to earn wages, and you will be compensated for that in most jurisdictions.
Okay. Well, I think that explained it a little bit more for those that didn't understand that each state does have its own statutory reasons or the amount of money that you can receive.
And that's why you should go to an attorney, because an attorney in your state will be expert. If they're a workers' compensation attorney, they'll be expert with what's required in that state, what you're entitled to, and how to navigate the system to get you to it. And if there's a dispute, they can represent you in a hearing to reclaim your benefits.
Okay, now some people may not go and reach for an attorney or reach out to an attorney to handle their workers' compensation because they're probably looking at it like, well, I'm not getting my full paycheck. I can't pay an attorney to represent me. So how would that work for someone who is on workers' compensation, receiving 2/3 of their payment? Clearly, they can't go get a part-time job or anything like that. At least they shouldn't be able to.
Exactly.
On workers' compensation.
This isn't sick leave, right?
Right, exactly. This isn't sick leave. So what could they do to get an attorney to assist them?
The good news there is that attorneys handling workers' compensation cases only get paid if there is a dispute and they're able to secure benefits for you arising out of the dispute. So what these attorneys will do is they'll help you file your paperwork, make sure everything goes smoothly, and they're hoping that if there is an opportunity to earn a fee because something gets contested, or maybe there is a permanency award and there's some negotiation over how much that's worth in terms of your benefits, because there is some flexibility there in terms of, it's not just, cut and dry. There's the opportunity to negotiate. They receive a percentage of what they recover for you, but that also has to be approved by the Workers' Compensation Commission or whoever it is in your state. So there's never a reason to pay an attorney up front for anything. You would only ever have to pay them a percentage of what they recover for you. If you went to an attorney and everything went completely smooth, there was no permanent injury, you just needed to fill out the forms and get them in there, then there may not be a basis for the attorney to ever get an attorney's fee for anything they did. But they're still happy to do that, because in the vast majority of cases there are going to be disputes that come up along the way that they can intervene and help with. And frankly, developing the relationship with the attorney means you might come to them for something else.
No, that makes sense. It really does. So basically, they get a contingency
A
fee.
contingency fee. To that extent, it is like personal injury cases where you don't have to pay up front. But the only difference is that the attorney's fee has to be approved by the body that's responsible for supervising and overseeing workers' compensation in that state. That's not true of personal injury cases.
So the attorney's not going to get like 80% and this
No.
person walks away with 20%.
No.
Because that's how people feel this happens.
If you do have an award, typically the attorney's fee is 20% or less of what they recover for you. So it's not even the same amount that you would normally have in a personal injury case, which is not limited by statute. But in the workers' compensation context, you're usually limited to a statutory amount for attorney's fees. That's usually about 20% of what you recover for the client, not including what they were able to get on their own without a dispute. So if they got all their benefits paid up to a certain point, and then there was a dispute, you only get that 20% of what you recovered as a result of the dispute.
Okay. So let's say you get a recovery and you have medical bills, because you said medical bills do get paid. Now, your recovery, 20% goes to the attorney, your medical bills are paid. What does the employee get?
So the employee is getting their wages, their lost wages, their benefits. That's 2/3 of what they normally make. And typically, that's about the average. And again, so you're getting your medical bills paid. You're getting paid for your time off from work at the rate of typically 2/3 of what you normally make. And again, there's nothing to pay out to the attorney. They don't get paid to get your medical bills paid. In some jurisdictions, though, if an attorney takes a case to court or to trial or to a hearing and they prevail, in some jurisdictions there can be an award of attorney's fees that's assessed against the employer or the insurance company as well. In which case, even if you do win, you don't pay the attorney's fee, the employer does. But that's more and more limited in most of the jurisdictions that I've seen, especially in this area.
Okay, good. Well, that's great to know. Now,
So there's no reason not to seek out an attorney. It's not going to cost you anything up front, may not cost you anything ever. Certainly it's not going to cost you enough to jeopardize your case just because you didn't want to pay a fee.
now that makes sense. So get an attorney. If you have a workers' compensation issue, get an attorney. Don't be afraid, I don't have any money to pay one. Get one. It's contingency basis. You're not giving money up front.
Perfect.
Great. So what happens? All right. So let's say, in my case, say I'm still the baker. I'm in there. I fell. Notice. Employer contested it. We went to court. We win. Yay! You get your 20%. I get my wages, and my medical bills paid. Right? How long do I continue to get my wages?
That's a good question because it depends on the state. As a general rule, if your injury is what's known as a so-called scheduled loss, meaning that there's a body part in this statute that we're referring to, you might get your wages based on the percentage of use of your body that you've lost, and when you receive that, you're done.
Okay.
Because they're basically compensating you based on how much of your ability to work you have lost. Now, you might not be able to go back to your old job.
Okay.
I had a client that injured, he was an electrician, he injured his knee. The knee is called is a scheduled loss, meaning that they have a value that it's might be like 300 weeks of your compensation, and you get a percentage of it based on how much of the knee you can't use. Maybe it's only 30%. So you get 30% of your compensation for 250 weeks or something like that. And what usually happens is the insurance company will want to work out a settlement and just pay it out to you in lump sum, call it a day, and close the file. In which case, that's where the attorney's coming in and negotiate that for you to get you the biggest return you can. From that point forward, the employer's got no further obligation to you. The insurance company's got no further obligation to you, with the one exception that they might have an ongoing obligation to continue to pay your medical bills, depending on how well your attorney negotiates to have that left open. But in terms of compensation, you won't receive any further compensation if you have settled your workers' compensation case and simply left the right to have medical bills open for a period of time or something like that. But that means you might have to go back and find another job someplace else that you're capable of doing.
Right. With your limited means. Okay. Well, that was great knowledge and great information. I'm sure the audience appreciate that because that's a lot to know what to do, what workers' compensation actually is, how much you get for it. I mean, because people just really don't know.
Yeah, and that's the value of having competent attorneys representing you in some of these things that come up. You're not expected to know all these things. That's why they're professionals to help you.
And that's great. So we're going to take a break right now. When we come back, we're going to do one of the favorite segments, which is Plead the Fifth. I'm going to ask you some random questions, and you're just going to answer them or plead the fifth.
All right, don't
ready?
embarrass me.
I'm going to try not to. Okay, we'll be right back.
You made your house a reality. Homeschooling yourself on loans, color-coding listings, and flushing every toilet in a 20-mile radius. If you can ace house hunting, you can do it for retirement. Get on track with tips at aceyourretirement.org.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. We're still here with my mentor, Mr. Glenn Garnes, a retired attorney, and now we're going to do Plead the Fifth. I'm going to ask you some random questions. You can answer them, and then we'll go into cheat sheet where you're going to give the audience, like 3 tips, simple tips for them, okay?
Fantastic.
You ready?
I'm ready.
All right. Have you ever let someone take the blame for something you did?
Well, just yesterday.
No! Yes or plead the fifth?
Yes.
Shame. What is something that people think you would never do, but you have?
So it doesn't have to be yes or no then.
No.
When I was in high school, I climbed up the side of our building and was talking to other students in the classroom, the biology classroom.
So you was that kid that just disrupted everything?
I was the class clown.
Okay.
Yeah, absolutely.
Now, what is the most embarrassing thing your parents have caught you doing?
Oh man, what is the most embarrassing thing that my parents
have caught you doing?
Wow. I don't know how to answer that one. It's not that I want to plead the fifth. I just don't know what it is because it could be a lot.
You're taking the fun out of it.
All right. I'm trying to work on. I'm trying to remember what I did that was embarrassing. I was probably eating something off the floor that fell out of the refrigerator. I don't know.
That's not embarrassing. That's just gross. Who is your celebrity crush?
My celebrity crush. Wow, it had to be Mariah Carey.
Really?
Yeah, absolutely love her. And I'll tell you why. My favorite song of hers is Hero, and it has some deep meaning to me for reasons unrelated to the practice of law. But nevertheless, she's my girl.
Okay, and what is the silliest thing you have an emotional attachment to?
Oh, we have guinea pigs at home.
Really?
I'm just saying, Now, see, I didn't plead the fifth. I was transparent.
You did. You didn't plead the fifth not once.
Exactly.
That's good job. High five.
All right. I appreciate it. That wasn't as bad as I thought it would be.
No, of course not. No, of course not. So we're going to go right into cheat sheet, and that's where you're going to give the audience 3 quick tips
Okay.
for them, okay?
So this is related to workers' compensation. So when you go to the doctor, you want to make sure you get your disability certificate because your employer is going to want to have documentation that the doctor has authorized you to stay off because you could lose your benefits and it takes time to get them back on if you don't have the documentation. Save all your receipts for medications and things like that so that you get reimbursed. In most states, you get reimbursed for your mileage expenses to and from the doctor, to and from therapy, to and from your going to the grocery store, the pharmacy to purchase your medications. Save all your receipts, give them to your attorney. They will take care of everything.
Oh, cool. So that's your 3 tips.
That was 2.
That was 2.
The third one is don't get caught doing things that are inconsistent with how serious you say your injury is. If your back is hurting, you should not be at the gym.
Right.
Because let me tell you why. There are insurance companies that hire private investigators to videotape you doing things that are completely inconsistent with what you say is the nature of your injury, or the seriousness of your injury. You do not want to be caught on tape because it will be the end of your case.
Right. Or lifting, cases
Doing
of
work
water.
in the yard and stuff
Right.
like that. Yeah, exactly.
You
Being
can't do
home
that.
doesn't mean being in the yard doing yard work.
Right.
You'd be surprised how many times people get
Or
caught doing
dusting
that.
up in the corners.
Exactly,
And
exactly.
you have a back strain. So those are great tips. And I do thank you for being a guest on the show.
My pleasure. I'm glad to be here.
Oh, of course. We're going to have you come back, of course.
You know I will.
Yes, thank you. And thank you, audience, for tuning into the show, sending in your questions. Please don't forget to subscribe. You can go to the website, which is www.mbunderoath.com. We're on all the social medias, Facebook, YouTube, Twitter, Instagram. I believe we're on Periscope as well. So check out the old videos and shows that we have, as well as the legal tips that we send out weekly. And just enjoy everything and just be back. We'll see you next time.